So let's go now to disobedience, refusal of assistance, and maltreatment of prisoners. So this is chapter 6 of Title 7. So what are the specific articles? Well, let us start with Article 231, that is your open disobedience. Article 232 is the disobedience to an order of a superior officer when said order was suspended by an inferior court. Article 233, there is this refusal of assistance. Article 234, there is this refusal to discharge elective office. And last is Article 235, the maltreatment of prisoners. So let's begin our discussion with Article 231, that is your open disobedience. So what are the elements? Who is your offender? Offender is a judicial officer or an executive officer. And there is this judgment, decision, or order of a superior authority. That judgment, decision, or order made by the superior authority, it was made within the scope of his jurisdiction, and it was issued also with all the legal formalities. But what did the offender do here? The offender openly refuses to execute the judgment, the decision, or order of which he is duty-bound to obey. And the offender cannot state any legal justification why he openly refuses to execute that judgment, decision, or order. So ano ang example natin dyan? Like for example, you filed a case in the RTC. You want to present a certain evidence, but the RTC judge does not want you to present this evidence. So ano ang ginawa mo? Umakyat ka ng Supreme Court. Nag-file ka ng mandamus case, and the Supreme Court granted your mandamus. If the RTC judge openly refused to obey the order of the Supreme Court, then that judge could be liable for Article 231. So Article 232, what are the elements? Again, the offender is a public officer. But itong si public officer ay merong boss, meron siyang bossing. And the bossing issued an order. An order is issued by his superior for execution. But ano ang ginawa ng ating offender? Ang ginawa ng ating offender is he suspended the execution of the order issued by his superior. Again, the offender suspended the execution of the order issued by his superior for any reason. Number 4, nung nalaman ni bossing na sinuspend ni offender ang execution ng order, the bossing disapproves that judgment of our offender. But what did the offender do here? Despite the disapproval of the suspension of the superior, still the offender disobeys. So ito ang ibig sabihin ng disobedience to an order of a superior officer when said order was suspended by inferior officer. So let's go now to Article 233, that is your refusal of assistance. So what are the elements? Again, the offender is a public officer. And what happened? There was this competent authority. He demands from the offender or from that public officer that he lends his cooperation towards the administration of justice or other public service. But itong si offender or itong si public officer, he fails to do so, and he fails to do that maliciously. So, what is our example? Ang example natin dito is that case decided by the Supreme Court, wherein the Supreme Court found the Chief of Police guilty of Article 233. Ano ang sinabi doon ng Supreme Court? That Chief of Police is guilty because he refuses to serve the summons of a fiscal after ni fiscal mag-request kay Chief of Police na tulungan siya sa pagsuserve ng summons, but still si fiscal fails to do but still si Chief of Police fails to do so maliciously. Let's go to Article 234, that is your refusal to discharge elective office. So what are the elements? Number 1, the offender is elected by popular election to a public office. So take note ha, your offender is an elected officer. Number 2, that elected officer refuses to be sworn in or he refuses to discharge the duties of his office. Number 3, there is no legal motive for the refusal to be sworn in or the refusal to discharge the duties of said office. But ano ang nangyayari sa Pilipinas? Ang nangyayari sa Pilipinas, those elected officers, they want to be sworn in kasi kung hindi ka manunumpa dyan, hindi papasok yung mga pork barrel mo, yung mga budget. But they do not want to discharge the duties of their office. That's the reality. But take note ha, why is Article 234 included in the revised penal code? Because once an individual is elected to an office, then it is not only a right that he should be sworn in and or he should discharge the duties, but it is now a matter of duty on that part of the individual. And take note again, ang pinag-uusapan natin dito is an elective officer. This Article 234 does not apply to an appointive officer. So let's go now to Article 235, that is the maltreatment of prisoners. Take note ha, Article 235 is a bar exam area, so please take note. Number 1 element, offender is a public officer or an employee and he has under his charge a prisoner or a detention prisoner. Number 3, he maltreats such prisoner in the following manners. So ano yung mga manner na yon? Number 1 is by overdoing himself in the correction or handling. So how did he do that? Is first by the imposition of punishment, and that punishment is not authorized by the regulation, or second, the punishment is authorized but he inflicted it in a cruel and humiliating manner. Nangyayari ba to sa totoong buhay? Maybe. May mga naririnig tayong mga kwento na kung ang kinaso dun sa isang tao ay rape, lalo na kung ang ni-rape ay kanyang sariling anak, then may mga nangyayaring kababalaghan. Nakikita nyo to sa mga news at saka sa teleserye, sa movies, that's uso. Another way of committing it is by maltreating the prisoner, and the reason why you maltreated such prisoner is you want to extort a confession or you want to obtain some information from him. Gusto mong umamin na yung tao. Let's explain further. Article 235. Sa Article 235, your offender is a public officer. But who is your offended party? Specific ang offended party sa Article 235. Hindi basta-basta kung sino lang ang offended party dito. So who are this? Number 1 is a convict by final judgment. Ito yung taong nahatulan na ng korte na siya ay liable for this specific crime. So, he is a convict by final judgment. Number 2, a detention prisoner. Maaring ito ay nadampot ng pulis at hindi nakapagpiyansa because he has no money. He was not able to bail himself. Then, he is considered a detention prisoner. So, these are the offended parties in Article 235. But take note that Article 235 does not apply if you are a person that nadampot ng police but you are not yet booked in the office of the police and placed in jail even for a moment. Bakit hindi nag-a-apply ang Article 235 kahit ikaw ay binugbog na ng police? Because by that time, you are not yet considered a detention prisoner. Please take note of that ha, importante yan. Ano pa ang kailangan mong matandaan under Article 235? There is no complex crime of maltreatment of prisoners with serious or less serious physical injuries. Bakit? Because if you read Article 235, very clear dyan nakasulat that in addition to his liability for the physical injuries or damage caused, then the public officer or employee is also liable for the maltreatment of prisoners. So take note ha, there is no complex crime of maltreatment of prisoners with serious or less serious physical injuries. So for application, let's read this 2012 bar exam question. There was this jailer, this is an MCQ, so there was this jailer, he inflicted injury on the prisoner because he has personal grudge against the latter. The injury that caused illness on the prisoner is an illness which lasted for more than 30 days. So what is the proper charge against the jailer? Choices are, number 1, the jailer should be charged with maltreatment of prisoner and also serious physical injuries. Number 2, or letter B, the jailer should be charged with serious physical injuries only. Number 3, the jailer should be charged with complex crime of maltreatment of prisoner with serious physical injuries. And letter D, the jailer should be charged with maltreatment of prisoner only. So what is the answer? Answer is letter A. Bakit letter A? Again, what did we say? There is no complex crime of maltreatment of prisoners with serious or less serious physical injuries. Bakit? Because very clear, see Article 235, that the public officer or employee is liable for maltreatment of prisoners, but he is also liable, sabi nga dyan ha, in addition to his liability, he is also liable for the physical injuries or damage caused. That is the reason why the answer is letter A. The jailer is liable for 2 offenses. Number 1 is maltreatment of prisoner, and number 2, serious physical injuries because the illness lasted for more than 30 days. Another bar exam question which was asked in 2012. There was this person, he was forcibly brought to the police headquarters. And what happened? When he was brought to the police headquarters, he was tortured, he was maltreated by agents of the law. Bakit siya binugbog? Because gusto ng mga policeman na umamin siya. They want to compel him to confess a crime imputed to him. So what crime was committed by the agents of the law? Answer is grave coercion. Hindi maltreatment of prisoner. Bakit? Again, you take note, who is the offended party in Article 235? Very clear that the offended party is either a convict by final judgment or a detention prisoner. If you are a person na dinala lang sa police station but you were not yet booked in the office of the police and placed in jail even for a moment, then you are not considered a detention prisoner. And the agents of the law in that case would also not be liable for Article 235. In our facts, the offended party was merely brought to the police headquarters, therefore he is not a detention prisoner. The agents of the law are guilty of grave coercion. Ano ba itong grave coercion? Malayong yan na topic, that is under Article 286. But just for you to understand, grave coercion is committed by compelling another person, that is by means of violence, to do something against his will. Kagaya ng nangyari sa facts natin. Ang tao ay binugbog para siya ay umamin. So, the person was compelled to do something against his will, and they did that by means of violence.